Alrighty, so this is Diesel We the People News. Okay, this video is without prejudice and or without recourse, alright? Must end on the UCC 1-308. All rights reserved, okay? Anything I say is just my opinion. I'm not an attorney, so I'm not going to give legal advice. Okay? Alrighty, I never look straight forward. I always look around me to be able to protect myself by any means necessary. So, let's go back to school. What do you guys think? This can be part 2.
Motion in limine. Motion in limine, not lemonade. We're not making lemonade here. But this is a pretrial motion.
Motion in limine, alright? M-O-T-I-O-N. I-N, and then L-I-M-I-N-E. That way you guys can spell it out and look on YouTube and find out a little bit more about it. Alrighty, let's proceed forward.
This is really, I'll just give you an example. I used to shadow a criminal law attorney around, and you know, before his trials, he would have these books full of these motion in limines, and you know, the judges don't necessarily love them. They would rather just have the parties do a trial on the merits and go for it. But there are some things that you want to suppress, or you want to, you know, stop your opposing party from mentioning the word insurance company, you know, or, you know, those kinds of things. So it's a motion that you file pre-trial before the trial seeking to suppress evidence, okay? So this comes up a lot in litigation if you're getting into pre-trial, the case is getting ready to go to trial. Motion in limine. All right, this one is per curiam, the next one. So you...
Alrighty. P-E-R. And then C-U-R-I-A-M.
Usually you have a, you know, let's say you have the Supreme Court. You have, let's say you have 9 justices and it's a 5-4 decision, and you go, wow, everybody's sworn to support the Constitution, but they have a completely different view of the Constitution. Well, such is life. But there are times when a court can come together and say, you know what, this decision's really obvious. We don't need dissenting opinions. We don't need concurring opinions. Let's just issue a per curiam decision. That means unanimous, a unanimous decision of the court, speaking as a whole, as opposed to any individual judge, okay? Per curiam, that's a great one. You see it all the time. Here's another big Latin term, prima facie. Okay, so
P-R-I-M-A. Then F-A-C-I-E.
have here, for example, negligence. In order to prove negligence, let's just talk about California. You need to show duty, breach, causation, and damages. That's bullet point number 2. And when you're pleading, let's say in your complaint, you need to plead all those elements. You don't need to prove it at the initial stage. You just need to make a prima facie case, or what they say, a prima facie showing that you meet the elements, that you've adequately pled these elements, that they're plausible. And if you can do that, it's prima facie. Your pleading would not be subject to a demur or a motion to dismiss in federal court, as the allegations are valid on its face. And that's really what prima facie means. Face, valid on its face, okay? So it refers to meeting all the necessary elements of a cause of action, at least facially speaking. Prima facie, you'll see it all day, every day in the practice of law, especially in litigation. Okay, next one is pro tempore. Pro temp, I think that we call it.
P-R-O-T-E-M-P-O-R-E.
Temp, or pro tem, sometimes you hear it, refers to a judge that's appointed on a temporary basis. Keyword here, temp, temporary. Are you catching on to the little tips here? Temporary basis. So your judge could be assigned to a judge pro temp. Temp. There you go. Easy, right? Quid pro quo. This essentially means a trade-off. It means
Q-U-I-D, then P-R-O, then QUO.
So this for that. I give you something, you give me that. And this is really important when you're looking at the law of contracts, where you are required to show consideration in order to have a valid enforceable contract. A contract is a promise or set of promises that the law will enforce. So a quid pro quo, that's your trade-off, and that is the glue that holds together a contract.
On one of my videos, if you hear towards the end of the last video that I was a witness to, the man says quid pro quo because the judge and attorney was planning on having a meeting behind closed doors without him, and he was what y'all call representing himself. So he should have been in there with them.
All right, we're getting near the end here. Qui Tam, what is this? I didn't know much about.
QUI and then TAM.
Qui Tam or Qui Tam. But I found it fascinating, and I eventually ordered a book on it because it was really interesting. But this is really if you know somebody that's ripping off the government, let's make this as simple as possible. They're ripping off the government, making false claims. It's actually known as the False Claims Act. You can basically go to, I believe it's the Attorney General, United States Attorney General, present the claim to them, and if they want to take the case, you get a percentage. I think it's 25, don't quote me, but you would actually get a percentage of the case while they're prosecuting it for you, while they're bringing the civil action or whatever they're doing to recover. So you are essentially, as bullet point 2 says, pursuing an action for the king and for yourself. So, and as I recall from the Qui Tam, is if the government doesn't want to take the case, then you're free to bring it on your own. So again, don't quote me on this because, this is a area of law all to itself, but it happens to be a Latin phrase. And if you know Qui Tam, if that pops up in your bar exam and you pull out Qui Tam, I mean, that's, be careful because the bar examiner might not know that one, but that's a key one. It's really a cool word. Qui Tam could make you some money too.
I had to say, that was kind of interesting right there from my behalf, right? I've heard this a couple times because I've been studying this and this and this and this. However, what I need to do is find out what the Latin term is, government ripping off the people. If you guys can figure that out, look it up and all that kind of stuff and learn that. Right? Alrighty, let's go.
All right, this is one of my personal favorites, res ipsa loquitur. Res ipsa loquitur.
All right, RES separated, IPSA separated, LOQUITUR.
Means this is Latin for not the think. It's supposed to say the thing speaks for itself. I must have been getting tired here. The thing speaks for itself, and this is often used in tort law, like a negligence case. The one I remember from law school is some guy is walking underneath a building, a big bag of, I think it was a bag of flour or cement or something. A bag of something fell on the guy's head. And he went to sue for negligence, and the defendant said, "Well, you can't prove who did it. You can't prove which one of us did it. So you got no case." And this is where the good plaintiff lawyer, and this comes up. You got to keep an eye out. This comes up. A good plaintiff lawyer will say, "Well, res ipsa loquitur. The thing speaks for itself, Your Honor." And what this does, this allows a presumption of negligence so that you can get through the motion to dismiss or the demur. It allows you to avoid basically losing the case. So this is a really fancy. Don't do what I do all the time. Try to spell loquitur with a C. I don't know why I do that. It's a mental brain hemorrhage that I have, but res ipsa loquitur, the thing speaks for itself. All right, res judicata, another great one.
Alrighty, RES, separated JUDICATA.
This just says a legal matter that has been litigated should not allowed to be litigated again by the same parties unless it's an appeal. Obviously, if you go to a trial and you lose, you should be able to appeal. People have appeal rights. But what res judicata says is this case, these causes of action have already been heard. You were the parties. You don't get to go do it all over again just because you're angry or something. So that's res judicata, also known as AKA action estoppel. Action estoppel.
That's actually what I know it by. Alright? I did not know the Latin word for the action estoppel.
And then I have here just contrasting this with collateral estoppel, which is what we call issue or claim preclusion. Issues raised and litigated should not be relitigated. So if you lost on copyright infringement, you shouldn't be able to come back and raise the issue again and do it all over again. Res judicata, collateral estoppel, two great ones there for you, 2 for 1. All right, the next Latin term you need to know, scienter. All right, this comes up all over the
SCIENTER.
place in law, constantly popping up in civil cases, fraud cases, criminal cases. And scienter basically refers to a full awareness of committing a tort or a crime. So you're fully aware what's going on. You have the scienter. Some people would call it the guilty mind. Some people call it knowingly, willfully, intentionally. So scienter is that full awareness of doing something wrong, is what I would say. Okay, scienter, that's a great word there. All right, we're getting down to the end. Stare decisis, this is kind of what...
STARE, then DECISIS.
Our legal system is all based on the doctrine of precedent. If we've already heard a case about Roe versus Wade, and we've already established what the rule is, the precedent is what it says it is. It's the trimester approach, as I recall. And so if you have another case that's what we call, quote unquote, on all fours, meaning all the facts are the same, the previous law, the precedent should be followed, and that is what we know as the principle of stare decisis. Decisis, once again, deciding cases based on previous cases. Okay, that's what we call, that's case law. And subpoena, what is a subpoena?
SUBPOENA, most common misspelt.
This is another word that people misspell all the time. This is a legal command from a court. This is usually a document stamped by the court or by an attorney directing someone to appear, to testify, or bring documents, or do both. And if you don't follow the subpoena, or you don't work it out with the attorney where you can fix the right date or do something amicable to both sides, this could be punished by contempt of court. So you don't want that. Punished by contempt of court. Court has wide latitude in issuing sanctions and doing what they want to do as far as contempt of court.
Is that criminal or civil?
And finally, there is the motion to quash. Some people like to call it, I think they don't know the law, so they're calling it motion to squash, which I think is pretty funny. I like the name, actually, and maybe we should push for that. But there is a motion to quash where you can try to quash the subpoena, and there's a variety of grounds that you could do that. I have other videos on subpoenas that are out there. If you want to watch those might be helpful for you. All right, and we're down to a final one or two. Respondeat superior. You can't go through law school. You can't go through the practice.
Alrighty. RESPONDEAT. Other word? SUPERION.
Of law without this word phrase popping up left and right, over and over, up and down, side to side. This is basically let the master answer. Let the master answer. Bullet point 3. What does that mean? Basically, it means an employer is liable for the torts or the wrongdoing committed by its employees within the course and scope of employment. The master needs to answer. So this is where you have employees that are doing things. Maybe you have employees posting copyright infringing material online as part of their job. You know, you don't sue the employees, you're going to go and sue the company. The company is liable under the doctrine of respondeat superior. So again, that's a great word. Pretty sure that's going to pop up in your bar exam somewhere, and for sure in the practice of law.
Also, the master would be city council and mayor above the police. So when they do wrong, then the master needs to be held responsible for their employees, which is the police, or council members and the sheriff for the deputies. Right? So anyway, there you go, y'all. Just we the people, just learning some Latin words. Alrighty, till next time, bye y'all.